Good evening, ladies and gentlemen, and welcome to our 12th session of Constitutional Revival with Royal Alexander. I welcome all of you back. I hope the weather is good where you are. It is cold and wet and rainy in Shreveport, but that in no way will ever in any way provide a way to stop the irrepressible spirit of freedom and patriotism that we feel. I am glad you're with us tonight. We have been plotting through tonight. We're going to do certainly the 12th, 13th, and 14th Amendments. And I'm also going to comment, as I do periodically, on things that are going on across the country, of which lately there are many. I again thank Joanne Woodard and David Hagar, without whom none of this would ever be occurring or have occurred. And to also note, David's company is named Beyond Innovative Technologies and Consulting, and he does a great job for us. Anyone wishing to review the material that we have been to can go to my YouTube channel, Constitutional Revival with Royal Alexander, which will catch you up on everything and anything you may have missed. And also, if you ever have a question about anything we cover, please email me at constitution.royalalexander@gmail.com. Constitution@royalalexander.gmail.com. Before I get into the 12th Amendment tonight, I want to talk about some of the things that have occurred this week. By now, you probably know that the Supreme Court case filed by Texas against the other states, Georgia, Wisconsin, Pennsylvania, and others, that case was dismissed by the U.S. Supreme Court, but I want to address why that was. The Supreme Court dismissed that Texas lawsuit against the other states on a single legal ground, and in a single sentence, that being that Texas did not have legal standing to bring the lawsuit. That's all the court said. Texas doesn't have legal standing. Unlike the news media, I want you to understand what that actually means. In order to be deemed to have standing in a legal case, and again, it's a term of art, obviously, as you know. In order to be able to have standing, the party bringing the lawsuit must demonstrate that it has suffered an injury to itself as a result of the misconduct of the defendant. So injury to another person or to the public at large, public in general, is not enough to confer legal standing. It has to be injury to myself, to the plaintiff, the person actually suing someone else, the defendant. So that is what is meant by the term judicially cognizable injury. Judicially cognizable injury. It just means an injury. Cognizable means recognizable by the judiciary, by a court. And the Supreme Court said there is no judicially cognizable injury on the part of Texas that would allow it to sue the other states that the court could grant standing to. This is what, when I say, for example, let me give you an example of what I mean by legal standing. I do not have standing, for example, to bring a lawsuit if my neighbor is injured. I live on a street with a bunch of different houses. If my next door neighbor is injured, I don't get to sue because my neighbor was injured. My neighbor, which is the directly aggrieved party, you'll hear me use that word, aggrieved. My neighbor is the directly aggrieved party, and my neighbor is going to be the one who has to file a lawsuit for their injury. I cannot do it. That's a good example of standing. However, I want you to know that in dismissing the Texas case for lack of standing, that only means that the court was addressing the threshold issue of standing. It had nothing to do with the merits of that case. The court did not reach the merits of that case at all. All the evidence, everything that we've talked about, seen, heard in the media, all the court said was, Texas, you don't have legal standing to sue these other states about the presidential election. Meaning, Texas, you have not shown you yourself directly, the state of Texas, were injured sufficiently to allow you to sue the other states. I disagree. Lots of people disagree. I think Texas has shown sufficient standing because when you're talking about a presidential election, if the election was not conducted honestly and fairly in other states like Pennsylvania and Wisconsin and Michigan and others, I think it does affect Texas, just like I think it affects Louisiana. In fact, I think it affects every other state in the country. So I disagree with the Supreme Court about legal standing, but of course I'm not on the Supreme Court. So it doesn't matter what I think in that regard, but I want you to know lots of people don't agree with the court's interpretation of Texas not having standing to sue those other states based upon basically the violations of their own state rules. Because as I'm going to get to in a minute, only the legislature can change the voting requirements and voting rules in a state. The Constitution gives that power directly and only to state legislatures. And that's another thing. Because Texas was one state suing other states, that fact gives the United States Supreme Court both original and exclusive jurisdiction. Original and exclusive jurisdiction, which is to me all the more reason for the court to have heard the case. Well, they didn't. They said, Texas, you lack standing. But that's all they said. That's all they said. So the media would make you think, oh, they looked at all of it. No, they didn't. They didn't look at anything but standing. And they said, Texas, you don't have standing. So they dismissed it. Keep in mind, there's lots of other lawsuits percolating throughout the country. So while that was a disappointment, it is by no means over. What do I mean by that? Well, as I said, the court didn't reach the merits. We feel strongly about the merits. As I said, legal standing is a threshold determination, meaning it's one made at the very beginning to decide whether the suit can even go on in the first place. It's not a merits determination. Merits is getting to the meat and potatoes of the issues. And we're going to get to that in a little bit. So don't let anybody tell you, oh, they dismissed Texas. Yeah, they did dismiss the Texas suit on legal standing, which has nothing to do with the merits of whether or not these other states that are being sued have conducted their presidential election vote the way that they're required to. Those are two very separate things, and I want you to know that. So, what are we talking about the merits? I think, I know the merits were unreached in this case, and I think the merits of the case are compelling. Why? Because the merits of this lawsuit are simply stated, and I've said it here before, and I've said it a lot to other groups in the last few weeks. The actions of non-legislative groups. What do I mean in a state? Like we're in Louisiana, that's Pennsylvania, right over here is Texas. Non-legislative bodies like governors. They're not legislative bodies. The governor is the governor and the legislature is the legislature. The state Supreme Court. The state Supreme Court is sure not the legislature. And these election boards, also non-legislative. So non-legislative groups like governors, state Supreme Courts, and election boards, those non-legislative public officials were clearly acting in an unconstitutional way. Again, in a clear reading, under Article 2, Section 1, Clause 2 of the U.S. Constitution, which we in this class went over months ago at the very beginning when we did Article 2, because the U.S. Constitution says that non-legislative officials cannot change, cannot alter the election and voting rules in a state without the approval of the legislature. What does that mean, altering the voting and the elections in a state? That only the legislature can do. What does it mean when a governor or a state Supreme Court does that? That means if your legislature, as reflected in your state constitution, Pennsylvania, I'm looking at you, if your legislative will directly from the U.S. Constitution, as reflected as everything is in your state constitution, because in fact it's the state constitution that creates the legislature in the first place. If what the legislature has laid out regarding voting rules, procedures, regulations, as reflected in the state constitution, as reflected in the state constitution, is not what is followed, then those non-legislative people, like the governor, like a state Supreme Court, like a board of elections, absolutely have no power to decide, you know what, we're going to allow no excuse absentee balloting. No excuses. Usually you have to have an excuse, like I'm going to be out of the state or out of the precinct that day. I'm a veteran. I'm disabled. There's a few very clear grounds to allow for absentee voting. But when a state legislature and in a way, or the Congress decides we're going to have massive mail-in balloting, if that's not allowed in your state, as reflected in your state constitution, laid out by the legislature, it doesn't matter the fact that we have COVID. COVID's not an excuse. If you don't allow for no excuse absentee ballots, then just because we have COVID doesn't mean you get to get around that, governor or commissioner of elections or state Supreme Court, because that's not what's reflected by your legislature in your state constitution. What else? Ballot boxes, these dropping off of ballots in a box somewhere. Can't do it. You got to have the signature, got to be sealed. If we don't have them by November 3rd, we're not counting them. All of those things, any deviation is unconstitutional, because the only group that has the power to change its own rules is the party that put them in place in the first place, the legislature. That's expressly and solely the authority to change, to create, and then to change these election laws, and they haven't been. And the way to change them in a state constitution would mean you'd have to amend your state constitution to allow no excuse, absentee balloting, or anything else. Well, none of that was done. None of that was done. Lots of violations going on here. For example, in some states, the ballot and the envelope the ballot comes in, that's mailed in, are public records, and you can't destroy them. And you can't try to make it authentic if you don't have the two together to compare a signature or to see the date, if they came in together, if it was sealed, whatever requirements each state has to receive an absentee ballot have to be followed. And you can't do that if, for example, you throw away or destroy the envelope, especially if your state considers that envelope to be a public record. So there is all kind of violations here, but only the legislature under, again, Article 2, Section 1 of the U.S. Constitution, only the legislature can make these changes. And that's including to its own state constitution. It's got to change it through a state constitutional amendment. So that Act 70, 77 or 70 that Pennsylvania passed was unconstitutional because it doesn't trump the state constitution. And the state constitution says we're not doing no excuse absentee balloting. We're only doing limited excuse. I've got to be away for the military. I'm disabled. I'm sick. One of those 3 or 4 clear exceptions. That's the only absentee balloting we're doing in the state of Pennsylvania. But they tried to get around that with Act 70. Nope. Pennsylvania legislature, if you're going to change your own state law, you got to do it in your constitution by constitutional amendment. You didn't do that. So all those ballots which came in late, suspicious, with no signature, a lot of them weren't even postmarked. In my view, you can't count them. Now, again, you know, it's going to require a court to have the guts to take that up and do it. So that's what I want you to understand. But I want to say this. After the Supreme Court's dismissal of the Texas suit for lack of standing, I am drawing the conclusion, I come to the conclusion that the only party with legal standing to bring a lawsuit alleging that they have been aggrieved is a state legislature itself. This is because, again, state legislatures alone possess constitutional authority regarding elections and voting. They alone possess it. So they alone can challenge. They have been directly injured. Unlike what the U.S. Supreme Court said about Texas. Texas, you have not been directly injured by something that happened in Pennsylvania or Wisconsin or Michigan. I disagree, but that's what the Supreme Court said. So Texas, you're not the right party to bring the suit. But I do think a state legislature could sue, in effect, its own state, saying, no, governor, board of elections, commissioner of elections, you have done something illegal. You have done something we did not allow you to do. We're the ones with the power. We're not allowing you to do it. And we set out what we will allow in our state constitution. So we're the aggrieved party. We're going to sue you, perhaps the governor, perhaps the commissioner of elections, whoever the appropriate party was that allowed these illegal votes to be taken and come in, sue them before the Supreme Court. And they would have to have standing, because if the legislature, which is the very body that holds and is vested with that express constitutional authority to decide elections and voting in our state, in their state, if they don't have standing, I don't know who would. So that's my feeling about what is going on right now. I do believe that the Supreme Court needs to hear this matter, however it accepts the case. Somebody's got to have standing. I think the U.S. Supreme Court needs to hear this case. I do think it is too important for the country. I think there's really no way around it. There's 75 million people voted for President Trump. Many of them think that none of this is legitimate. And Joe Biden may think he's going to be sworn in. And if he is sworn in as president, he's going to be immediately considered illegitimate. So I just want to share those thoughts with you. I disagree with what the court did in dismissing the Texas case for lack of legal standing. But I do want you to know that that's all they addressed, legal standing. They didn't do anything about the merits of the case. And I think the merits are a strong argument. And it's based expressly in Article 2, as I've just discussed. So let's keep watching, keep praying, keep speaking out. It's not over. There's still lots of lawsuits. There's that case in Wisconsin, I think it is now, in which it looks like China may have been directly involved in invading our voting system in that state and in cahoots with Dominion voting systems. So what I mean by telling you about that is I still think there's a lot we don't know. It's true that by statute, December 14th, which is, what is today? Today is the 13th. Tomorrow's the 14th. Tomorrow is when, by statute, the certification, the electors are supposed to meet typically in each state capital across the country on the 14th. Tomorrow's the 14th. But that's a federal statutory deadline. The only constitutional deadline is the swearing in of the president on January the 20th. So the rest are federal statutory deadlines. The next constitutional deadline is the swearing in of the president on January the 20th. So keep that in mind. A lot is still left unresolved. The states could still show, even without needing the Supreme Court, the states, I think, could refuse to certify certain electors. I think, again, that's within their express power. Now, they would have to do it. They would have to step forward, get together and say, we're not accepting this. But it would take courage, political courage, and sometimes it's hard to find political courage. So that's what I wanted to share with you about the Texas lawsuit and kind of where we are with the presidential election. Tonight, we are going to talk about the 12th Amendment, how appropriate, because we're right in the middle of all of it. The 12th Amendment is the electoral process, the electoral college, and it modified what happened to some extent earlier in the articles setting up the electoral college, how we do it today. But I just want to go back over it. I've mentioned it several times back and forth. What does the electoral college do? Well, the Electoral College is a process. It's not a place. So when Alexandria Ocasio-Cortez, the communist, the socialist, says, I think tuition ought to be free to the Electoral College too, that just means she's ignorant, which is the most charitable word I could use to describe her. She's ignorant because the Electoral College is not a place. It's a process. No one actually pays money or tuition to attend the Electoral College. It's not that kind of college, AOC. It's a place. It's a process. It's not a place. It's a process. The founding fathers established it in the Constitution, the Electoral College, as a compromise between the election of the president by a vote in Congress and the election of the president by the popular vote. I think the framers wanted the entire country to be involved with the presidential election. So they said, we're not doing it by popular vote, because if we do it by popular vote, the candidates are only ever going to appeal to the country's population centers, which are states like New York, California, Texas, Florida, the huge states, because that's where all the votes are. They wouldn't go to tiny little states most often, like Louisiana, or even tinier states like Rhode Island or Maine or Wyoming. They're not going to go waste their time there because there's just not many votes there. Well, the Electoral College, because you need 270 electoral votes to win, you've got to be sure and get electoral votes that you should get from every state that you should get them. And so that's why it requires candidates to fight mostly in the battleground states. But President Trump may not spend as much time in Louisiana, for example, because Louisiana is considered a red state. And he's pretty sure the Republican candidate's going to win Louisiana. He did, 58 to about 42, I think it was. So it's not that he's not paying attention to Louisiana. He just knows with a minimal effort, he's going to win Louisiana. So he's not going to spend that much time here. But if he thought he might lose Louisiana, I guarantee you he would be spending time here. He would have in the campaign. So it's still in play, just like in the blue states. I promise you, if Joe Biden thought he wasn't going to win New Jersey or Vermont, someplace like that, he'd be spending time in Vermont because he's supposed to win Vermont because it's a blue state. But Biden still needs Vermont's electoral votes, just like Trump still needs Louisiana's electoral votes. But people say, well, they don't really come here. Right. They'd come if they thought they weren't going to win them. So where do they spend their time? In those battleground states where they desperately need those electoral votes that could go either way. It's why they spend all their time in Pennsylvania and Michigan and Ohio and Minnesota and Wisconsin. It's where a bunch of states President Trump brought back into play that many people thought Republicans couldn't possibly win. Well, he won them 4 years ago, and I think he won them again, but we may never know the truth about that. My point is about the Electoral College. It does require candidates to go get electoral votes from every state in the country, even with the states that just have one or three, because they need all three. If Biden gets to 269, it takes 270 to win. If Biden gets to, say, 267, and say Maine, and again, I lose track of the little states, how many each has. Let's assume Maine has 3 electoral votes. If Biden gets to 267, he better not lose Maine, because that 267, he needs Maine's 3 votes, electoral votes, to get to 270 and win the presidency. So that's why the Electoral College is so important. It's important to remember, when we go vote in our state, we think we're voting for President Trump. But what we're really voting for is the electors in each state, who are on a slate of candidates. The Democrats have a slate of electors. The Republicans have a slate of electors. The Libertarian Party has one. The Green Party has one. You're voting essentially for that slate of electors, because if Trump wins Louisiana, then his 8 electors, and again, Louisiana has 8 because we have 6 members of the U.S. House and 2 U.S. senators. 6 and 2 is 8. Louisiana has 8 electoral votes. Every other state is the same way. California, I'm always guessing about California, but let's assume California has 57 members of the U.S. House of Representatives. Therefore, California would have 57 in the House, and there are 2 senators, making 59. Or maybe it's 55 now, members of the U.S. House for California, and 2 senators, giving them 57, giving the state of California 57 electoral votes. 55 in the U.S. House, 2 senators. 55 and 2 is 57. So that's how it's done in every state. The number of the U.S. House plus your 2 senators. And that's how many electoral votes your state has. So but I want you to know that most states have a winner-take-all system. A couple of states, let's see, Maine and Nebraska does it slightly differently. They have a proportional representation where you win a congressional district here, someone else may win a congressional district there. But other than Maine and Nebraska, I'm pretty sure every state is winner take all, which is the simpler way of doing it. So after a general election and after the electors in each state meet, the governor of a state prepares what's called the certificate of ascertainment. The certificate of ascertainment, listing the names of all the individuals on the slate for each candidate. The certificate of ascertainment also lists the number of votes each individual received and shows which individuals were appointed as each state's electors. This is all in the certificate of ascertainment. Each state's certificate of ascertainment is sent to the National Archives and Records Administration, in addition to the other places it's sent, including, of course, the United States Congress, which is going to count those electoral ballots on January the 6th. January the 3rd is when the new Congress is sworn in, by the way. So the meeting of electors takes place on the first Monday after the second Wednesday in December, which is then this year, December 14th, tomorrow. The electors meet in their respective states where they cast their ballots for president and vice president, and each state's electors' votes are recorded on a certificate of vote. It's called the certificate of vote, which is prepared at that meeting by each state's electors. Each state's certificate of vote is sent to Congress, where the votes are counted as part of this electoral process. Each state's electoral votes are counted in a joint session of Congress on the 6th of January. That's 3 days after the new Congress is sworn in. Members of the House and Senate meet in the House chamber to conduct the official count of electoral votes. A lot of this is pro forma because typically we know, who the president-elect is. A lot of people think we already do, but I myself do not think it has been an honest, legitimate process. So I'm withholding judgment, but they're going to meet in a joint session of Congress on the 6th of January and count the electors. Again, both houses will be there. The vice president, as president of the Senate, keep in mind the vice president of the United States is the president of the Senate and always votes if there's a 50-50 tie. You know that already. Presides over the count and announces the results of the vote. So the vice president will still be Mike Pence on January the 6th, because if Joe Biden and Kamala Harris are sworn in, it won't be till the 20th. So Vice President Pence will be presiding over this thing we're talking about. The president of the Senate then declares which persons, if any, have been elected president and vice president of the United States. I do want you to know that the Constitution also states that if a member of the House or a member, and you got to have both, one member of the House and one member of the Senate, if they object to this electoral count, then a whole new process kicks in. And that's not in the 12th Amendment, and I'm not going to get sidetracked right now. But a whole new process kicks in If one member of the House and one member of the Senate objects, and one member of the U.S. House from Alabama has already said he is going to object, it then just requires one United States senator to also object, to then kick in essentially a review of all of this. If I were in the Congress, I would object from my own state, period. Regardless of if someone, even though it only requires one state, and this congressman from Alabama already said he did it, I would object if I were in the U.S. House or U.S. Senate, just the same. If you believed it's not legitimate, I wouldn't rely on anyone else objecting. I would object as a member of the U.S. House or the U.S. Senate, kicking in to action this other review, this review process. That could be very important if a member of the U.S. House and a member of the U.S. Senate do that. And I'm certain, again, one already said they do it in the U.S. House, and I'm certain maybe Ted Cruz, maybe Rand Paul, someone like that will object in the Senate. So that is also one of the reasons I am not yet ready to concede that Vice President Biden has won this election, because there's other things to play out that don't have anything to do with the U.S. Supreme Court. For that, by the way, the U.S. Supreme Court doesn't affect this. So don't think it's over. That's the electoral process. When we vote, we're actually voting for electors, even though we vote for the president and vice president. And we think, well, I'm going to vote for President Trump because that's whose name we push. By pushing his name, you're actually voting for the slate of electors who pledge to vote for him in the Electoral College. And I know most of you already knew these things, but that is a refresher of the 12th Amendment. Let me see if there's anything else I want to tell you about the 12th Amendment. Yeah, those are the most important things. There's the inhabitant clause of the 12th Amendment, which suggests strongly that the president and vice president cannot be from the same state. Although it doesn't expressly say that, what I think would not be allowed, you remember in 2000 when Governor Bush at the time and Dick Cheney got together on a ticket. At the time, they were both residents of the state of Texas. Well, to avoid any problem with the 12th Amendment, Vice President Cheney quickly changed his state of residence to actually his home state, which was Wyoming. So then there was no problem. Bush was from Texas, Cheney was from Wyoming, and so there was no potential constitutional problem under the 12th Amendment. So that inhabitant clause is in there. Let me see if there's anything else. I think the Electoral College was a brilliant thing. I think the framers, as they were in so many other aspects of the Constitution, were brilliant to require the entire country to be involved, not to let the Congress pick the president, except in the contingent election. If this thing isn't resolved, if the electors are not put in place by the deadline, then this election, if neither candidate gets to 270, this election, presidential election, is going into the House of Representatives, where each state has one vote. So it doesn't matter that there's a Democrat majority. If this presidential election could somehow, if these states didn't send forward their electoral votes, and Biden and Trump neither got to 270, this would automatically kick into the House of Representatives, where under the Constitution, each state gets one vote. So it doesn't matter that the Democrats are in control of the House. Each state, 50 states, each gets one vote, 50 votes. And right now, about 26, if not 27 of the states are dominated by the Republican Party. So presumably 26 or 27 of those votes would go to President Trump and he would be reelected. But we're not to that contingent election. We're still on the outside waiting to see whether or not all the electoral votes will be certified and sent, transmitted, and if any other challenges or objections are made. So it's not over yet, but that's what would happen in a contingent election in the U.S. House of Representatives. All right, that is the 12th Amendment. A lot going on, a lot to unpack. And each day we see another twist of it. And I just hope that it doesn't matter who you wanted for president. It affects all of us if we don't have a legitimate election. The most powerful tool we have, as I've referred to it, our sacred right to vote. It was fought for and died for. We have multiple, references to it in the articles of the Constitution, and there are multiple constitutional amendments that clearly grant to different groups the fundamental right to vote. If our votes are stolen, or if they're degraded or injured by what some other state does, I think that's going to be a real problem for this constitutional democracy that we are living in. No matter who you voted for, we've got to know that it's honest. And I don't think it's been honest this time. But I'm not on the Supreme Court or any other court. So I'm going to leave the 12th Amendment for now. And let's go to the 13th Amendment. The 13th Amendment is what I call part of, the Reconstruction Amendments after the Civil War, the 13th, 14th, and the 15th. But tonight is the 13th. What does it say? The text of the 13th Amendment is that neither slavery nor involuntary servitude, except as a punishment for a crime whereof the parties shall have been duly convicted. They can put me in slavery and servitude if I've been convicted of murder. They can put me in jail. Neither slavery nor involuntary servitude shall exist within the United States or any place subject to its jurisdiction. And Congress, in the second part of the 13th Amendment, Congress shall have the power to enforce this article by appropriate legislation. What it really does is the 13th and 14th and 15th Amendments. The 13th eliminated slavery and any form of involuntary servitude. By its adoption, because some states after the Civil War, and keep this in mind, it wasn't just the southern states that had slaves. Northern states had slaves too, but the Emancipation Proclamation just addressed, it says, the Emancipation Proclamation just freed slaves. All persons held as slaves are henceforth shall be free in those states that had been in rebellion against the United States. Well, what about those states that had slaves that had not been in rebellion against the United States? The Emancipation Proclamation did not address that. So that's why we had the 13th Amendment, which came in and said, the word servitude is larger than just the meaning of the word slavery. Everyone is now free in every state in America from slavery. That's what the 13th did. So that's clear, unquestioned. No more slavery nor involuntary servitude. But what about people who are like indentured servants? They're not slaves exactly, but they're also involuntarily servitude. Well, the word in those cases, the Supreme Court started holding that the word servitude in the 13th Amendment is larger than the meaning of slavery. And it was obviously in the beginning to forbid all kinds of African slavery, every kind. But then later, once black slavery was completely eliminated, people said, well, it also forbids every other kind of slavery, now or hereafter. So it's called Mexican peonage, a Mexican peonage, which is the practice of forcing someone against their will to work to pay off a debt. Mexican peonage was also knocked out. Or the Chinese coolie labor system, coolie, C-O-O-L-I-E, the Chinese coolie labor system, which would allow people to also be imprisoned for some other sort of debt or for some other purpose. They could be indentured, they could be held against their will. It knocked out the Chinese coolie system and the Mexican peonage system, as well as black slavery, which is the whole reason the 13th Amendment came into being in the first place. Now, keep in mind, involuntary servitude is now broadly enforced. It's to forbid work by the use of threat or physical restraint or injury or through law. It's applied broadly today. Involuntary servitude is defined broadly to include forbidding work forced by the use of the threat of physical restraint or injury. We're not having any of that in the United States. You can only be put in jail today if you have been convicted of a crime where the sentence, the punishment, was clearly laid out ahead of time, and a jury of your peers, or you pled to it, or a jury of your peers has convicted you of a clearly defined crime. Other than that, and some other people have tried to use the 13th Amendment in a more creative way for things like mandatory community service. You're forcing me to do that. That's indentured servitude. Or taxation. That's a pretty creative argument to say, if I don't pay my taxes, you're going to put me in jail, and that's indentured servitude. Or the draft, the military draft. They've tried to argue, creative lawyers have tried to say that all of that amounts to involuntary servitude in a way that violates the 13th Amendment, but the Supreme Court has not bought any of that. They've said, no, it doesn't. Those things are part of living in a civil society, that community service as a part of a repayment in atonement for a crime, or taxation, which the Supreme Court has, which the Constitution itself makes clear the Congress can levy a tax, or the draft, the military draft. But those are creative arguments, and you never know the real bounds of something if you don't test it in court. So that's the 13th Amendment. Again, neither slavery nor involuntary servitude, except as a punishment or crime whereof the party shall have been duly convicted. Other than for a crime, we're not having slavery nor involuntary servitude in the United States or any of its jurisdictions. So that's on the heels of the Civil War. It's the first of what I call the Reconstruction Amendment. That's the 13th Amendment. Now, let's roll into kind of what I call the mother lode, the 14th Amendment. It is, yes, good, we have time to do it. The 14th Amendment, there's a lot in it, but tonight we are going to focus on the parts that are most common, what you'd know best, and that are most of the times end up in litigation or being disputed based upon. So, as my law professor used to say, there's no better place to begin than with the text itself. So here is, tonight we're focusing on section 1. Tonight we're going to look at the text of section 1 of the 14th Amendment. All persons born, and every word means something. Keep that, we've been through the articles and we've been through a bunch of amendments now, and every one of the words means something. Section 1, 14th Amendment. All persons born or naturalized in the United States and subject to the jurisdiction thereof. That clause alone has been the basis for a lot of litigation. Are citizens of the United States and of the state wherein they reside, period. No state, and we're talking about states here in the 14th Amendment, no state shall make or enforce any law which shall abridge, which means infringe, encroach upon, abridge the privileges or immunities of citizens of the United States, which means any other state. Nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. Now, before I tear this apart, we're going to go back over the text. So please listen. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. No state shall make or enforce any law which shall abridge the privileges or immunities of citizens of the United States, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. That's a lot there. And there's supposed to be a lot there. It addressed a lot of problems that the country thought, the Congress thought were existing after the Civil War. So let's tear it apart now. What does it mean? What does what I just said mean? Because many states continued to pass laws that restricted the rights of former slaves, on January 13th, 1866, remember the Civil War ended in 1865, Congress passed and sent to the states for ratification the 14th Amendment. Ratified it was on July 9th, 1868. So it took 2 years. The 14th Amendment granted citizenship, U.S. citizenship, to former slaves and others that I'm going to get to in a minute. In addition to granting citizenship to slaves, it also contained 3 new powerful limits on state power, on the power of each of the 50 states. What are they again? The first is a state shall not violate a citizen's privileges or immunities. That means any rights that we enjoy here in Louisiana as a resident and citizen of Louisiana, someone from Texas who comes over here, they enjoy too. You can't say, we can't say, we're going to prefer the citizens of our own state when it comes to the rights that were granted Louisiana's own citizens. Just like a Louisiana citizen going to Texas cannot be discriminated against. The same privileges and immunities enjoyed by everyone who's a citizen and resident of the state of Texas is enjoyed by somebody from Louisiana or any other state that goes to visit Texas. That's the first one. A state shall not violate a citizen's privileges or immunities. A state also cannot deprive a person of life, liberty, or property without due process of law. And in a minute, I'm going to explain to you that there's both procedural and substantive 14th Amendment due process, but not yet. And the third, of course, is that a state must guarantee all persons the equal protection of the laws. That it's just a very powerful amendment. How so? These limitations on state power dramatically expanded the protections of the Constitution. Prior to the adoption of the 14th Amendment, the Bill of Rights only limited, the first 10 amendments only limited actions of the federal government, the Congress. But the 14th is now limiting the actions of state governments as well. the Supreme Court in what's called the doctrine of incorporation. The Supreme Court, the U.S. Supreme Court, through the doctrine of incorporation, has since interpreted the 14th Amendment as applying to almost every provision in the Bill of Rights, in the first 10 amendments. So now the restrictions on states, what the U.S. Constitution puts on, applies to the states too, even in those places where it only is addressing the federal government, the Congress. Through the doctrine of incorporation, those same rights apply to the states in almost all of the 10 amendments of the Bill of Rights. This is why when we're talking about, for example, the guaranteed rights of citizens to all persons born or naturalized, the right of citizenship in the 14th Amendment, the question about illegal aliens is just because they were born here, their parents are illegal, so now they're born here. But if they're born to parents who aren't here legally in the first place, and they're not even subject to our federal jurisdiction thereof, like we just said, and subject to the jurisdiction thereof. If you're in this country illegally, are you subject to the jurisdiction of this country? I mean, you're breaking our law by being here. That's a huge question. But anyway, by specifically granting citizenship to all persons born or naturalized, the 14th Amendment not only guaranteed citizenship to former slaves, but to most children born within the United States, even if the child's parents are not and cannot become citizens. They were born here, even if the parents were here illegally. So they're American citizens. Now, again, that's a very broad grant of citizenship. However, that broad grant of citizenship in the 14th Amendment is limited to those subject to U.S. jurisdiction. In the beginning, Native Americans who were governed by tribal law were not guaranteed citizenship by this amendment. They could get it through other ways, by marriage, marrying an American citizen, or by treaty or by military service, but they couldn't get it directly. However, in 1924, with the passage of the Indian Citizenship Act of 1924, Congress granted the rights of citizenship to all Native Americans. However, subject to the jurisdiction thereof is still debated. Who gets to be an American citizen? I think it's a hard argument to make that you were born here, but your parents are here illegally, but just because you were born here, you're an American citizen. And again, that's all on how we want our country to be, what we want our immigration laws to be, but that's what the 14th Amendment says. So let's talk about privileges and immunities. In the beginning, the privileges and immunities clause we just went over was interpreted very narrowly by the Supreme Court. But since then, the court has said, no, and I mean in the last 50 years, the court has said, in subsequent cases, the Supreme Court has recognized several federal privileges under the Privileges and Immunities Clause, that such as the right to travel from state to state. We get to cross this whole country. We can get in our car in Louisiana and go straight to New York City. So that's one of them, the right to travel. We enjoy the same rights, even though we're Louisiana citizens, when we get to New York, the state of New York, as every citizen of the state of New York enjoys. New York cannot discriminate against us because of the Privileges and Immunities Clause. The right to petition Congress for a redress of grievances. We also have that in the First Amendment. The right to vote for a national election, national officers, and so forth. But the Privileges and Immunities Clause is very important. You can't favor your own citizens. You have to treat outsiders, so people from other states, the same way. And the Privileges and Immunities Clause is very important for that. And keep in mind the exact wording of it. No state shall make or enforce any law which shall abridge the privileges or immunities of the citizen of the United States, meaning of any other state. So that's a powerful protection for us in any other state than the one we are residents and citizens of. All right, I mentioned procedural due process. The 14th Amendment's due process clause essentially means notice and the opportunity to be heard. That's procedural due process. Procedure. If the state's going to move against me in a criminal way, I have to have notice of it and an opportunity to be heard, to defend myself. That's how the due process clause has been interpreted, to protect against arbitrary state legislation. The state can't just pass a law and then lock me up. I have a right to fight it. That's procedural, 14th Amendment, procedural due process. No state, again, we're talking about states, no state like Louisiana, I'm protected by the federal Constitution from the state of Louisiana, because I'm a resident and a citizen, from taking away my property or otherwise jeopardizing my life or my liberty without giving me a fair and impartial way to defend myself. That's procedural due process. Procedural due process also requires that, and that's more substantive, but really what procedural due process guarantees is fairness. It requires the government to use even-handed procedures if it's going to act in an arbitrary way. It can't do that. A state cannot just say, I don't like him, go lock him up. No, under 14th Amendment procedural due process, I have to have a right to defend myself. That's not being able to be deprived of life, liberty, or property without due process of law. And what's due process? Part of it is procedural due process, meaning I have a right to know what I'm being charged with, a notice of it, and an opportunity to be heard to defend myself. That's procedural due process. What is substantive due process? It's a whole different body of law, but I want to share with you. The Supreme Court has found, and I'm going to quote the Supreme Court now. No sense in my quoting them, but in my paraphrasing. The Supreme Court has found that the 14th Amendment, its due process clause, protects individuals from arbitrary state laws or actions that interfere with fundamental liberties. More than offering just a process of fairness, which is what procedural due process is, notice and an opportunity to be heard. More than that, courts have found that 14th Amendment substantive due process prohibits states, again, states. The 14th Amendment is all about keeping the states from being able to move against me in an unfair way. Courts have found that the 14th Amendment's substantive due process prohibits states from harming an individual's ability to fully participate in society. Liberty, the court held in a particular case, Meyer v. Nebraska, liberty, the court held, quote, denotes not merely freedom from bodily restraint, which I'd be fighting with procedural due process, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience, which of course is protected in the First Amendment, free exercise also, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. That's where that liberty interest in 14th Amendment substantive due process comes from. Again, more than offering a process of fairness, it offers fairness, which I've addressed as procedural due process. But more than that, more than offering a process of fairness, courts have found that the 14th Amendment prohibits states from harming an individual's ability to fully participate in society. Liberty the court held in Meyer, liberty denotes not merely freedom from bodily restraint, but also the right of the individual to contract, to engage in any of the common occupations of life, to acquire useful knowledge, to become skilled, to become trained, to become educated, to marry, to establish a home and bring up children, to worship God according to the dictates of his own conscience, and generally to enjoy those privileges long recognized at common law as essential to the orderly pursuit of happiness by free men. That's powerful. That's powerful. That is where substantive due process comes from. And there's a long line of cases about individual freedom, about marriage, about contraception. But 14th Amendment substantive due process also is what gave us Roe v. Wade. And I can tell you that I will never believe that the liberty interest of the 14th Amendment, while it may guarantee the right to privacy in a number of areas, including family and faith and relations between couples, intimate relations between couples, it does not, to me, and never will include the right to abort an unborn baby. But that's where it comes from. 14th Amendment, substantive due process, the Liberty Clause of the 14th Amendment. And it is not in there, and I will never believe it should be found in there. And I think the court in 1973 in the Roe v. Wade decision was illegitimate in finding a right to abortion in the liberty interest of the 14th Amendment. But that is what the court held. So 14th Amendment substantive due process is a powerful right and prong of the due process clause of the 14th Amendment. I'm going to do equal protection briefly. It's easier to follow. Again, equal protection is part of the 14th Amendment. It's a restraint on the state, as the whole rest of what we've just discussed is also. The 14th Amendment is a restraint on the state. The Equal Protection Clause of the 14th Amendment limits the ability of states to discriminate against people based on their race, national origin, gender, or other status. For example, the clause has been used to guarantee voting rights. Absolutely, the Voting Rights Act. School integration, the rights of women and minorities to equal employment opportunities, and the rights of immigrants, for example, to attend public school. The equal protection of the laws tells the states you cannot treat people in your states differently from other people in your state. Really, what equal protection means is that similarly situated people have to be treated similarly. You can't treat some people in your state differently than you treat others, especially when we're talking about things like race, national origin, gender, or other immutable human characteristic. If it's an economic regulation where it reaches people differently, that's one thing, because economic regulations don't address what are often called suspect classifications: race, national origin, gender, and other status of human beings, these immutable characteristics, I call them. But the Equal Protection Clause means that in a state, again, it limits the ability of states to discriminate against people based on their race, national origin, gender, or other status. Equal protection of the laws. White people have to be treated the same as black people. Red people have to be treated the same as green people. You cannot, national origin, race, gender cannot be a grounds to treat people differently. And that otherwise they won't be receiving the equal protection of the laws in a state. It tells every state you've got to treat people the same. They have to have the equal protection of the laws. Similarly situated people have to be treated similarly. And that's really, for our purposes, what the 14th Amendment does. It's powerful. They're all powerful, but privileges and immunities, it's, again, here it is. All persons born or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. And no state shall make or enforce any law which shall abridge the privileges or immunities of citizens of another state. Nor shall any state deprive any person of life, liberty, or property without due process of law. And that's both procedural due process and substantive due process. And finally, no person can be denied within a state's jurisdiction the equal protection of the laws. So for our purposes, that is the 14th Amendment. It is very powerful. They're all powerful. But it is invoked so often on the grounds we just went over. So I don't see any question tonight, but I hope that you stay with me the whole time. The 14th Amendment is hugely important. What we talked about tonight too, the Electoral College is very important. The 13th Amendment as well, slavery, neither slavery nor involuntary servitude, which means no other form of indentured servitude either. So we're not doing any Mexican peonage and no Chinese coolie labor system. And of course, the 12th Amendment is the Electoral College, which the framers in their brilliance put in place so that the entire country would be electing the president and the vice president. But that is where we are going to leave it tonight. If you haven't seen all of the classes to catch up, please do. And we will be in touch soon. Thank you for being a part of this tonight. Good night.